I'm Kate McBride for AdvisorOne, here today with Knut Rostad, Chairman of the Committee for the Fiduciary Standard and Regulatory and Compliance Officer at Rembert Pendleton Jackson. Thank you for being here today.
Thank you for having me.
So we've just come from this SEC study on fiduciary panel discussion.
Right.
So we've been immersed in this all morning, but being chairman of the committee, and I should say I'm a member of the committee, full disclosure, I wanted to talk with you about why does the fiduciary standard matter?
It matters for many reasons for investors. And the first one is that this study and the rulemaking that will follow will be the first time in 70 years that there's been an exhaustive review of how the regulatory regimes deal with retail investors. But it matters also from an historic point of view, in that it was just 3 and 4 years ago that we experienced the financial crisis. We had a huge financial meltdown, and the question is, what did we learn from that? Mm-hmm. And one of the key lessons was that there was an absence of ethics and accountability throughout the financial system. So we need to go forward and learn from that. But another way of looking at this is that in terms of why it is important is that the difference between the suitability / commercial standard on the one hand and the fiduciary standard on the other hand is a difference of kind, not a difference of degree.
So when you say a difference of kind and not degree, what is it? Why? Why is it different that way?
The fiduciary has a legal obligation to put the interests of the client first, just like a medical doctor, just like an attorney, just like the estate executor. A very high obligation.
Tell me again the difference between putting the investor's interest first and the advisor's interest
first. There
first.
are some very specific obligations that a fiduciary has that the suitability standard doesn't require. Number one, the fiduciary advisor must only recommend products that are in the best interest of the client. The suitability standard doesn't require that. Number two, the fiduciary advisor must control investment expenses. That's a huge difference. The suitability standard does not require that. Number three, for example, the fiduciary advisor must disclose all conflicts of interest that are material, and the suitability standard again doesn't require that. And number four is something that I think is very easy to understand the importance. The fiduciary advisor must disclose all expenses, all costs, everything that the investor will end up paying, and the suitability standard does not require that. And that, in fact, we see that in some of the research that suggests that investors do not know very often how much they pay for the products and the services they get. Many investors think that they pay nothing for the products and services they get. So those are just 3 or 4 of sort of very specific differences between the two standards.
You talked a little bit about controlling costs, and in the panel discussion you made a point about retirement assets.
Right.
And the difference, I think it was 1%?
1 percentage point. This particular calculation comes from the Assistant Secretary of the Department of Labor. And 1 percentage point difference over 35 years has the compounded impact of reducing the nest egg by 1/3, by a total of 1/3. So that is a huge difference in terms of what somebody is left with when they go into retirement. Just the basis of 1 percentage point added to the costs of their investments.
But controlling costs does not mean working for free, right?
No, absolutely not. And this is one of the myths out there. Not at all. Controlling costs means this is related to the duty of loyalty. And how can someone be loyal if they are not? How can an advisor be loyal if they're not providing a very competitive cost basis for the services, the products they're offering? It also doesn't mean you have to be the low-cost provider. And advisors who understand the duty of execution, best execution, understand this intuitively. Best execution does not mean that you have to be the low-cost you have to follow only the low-cost execution route. It just means that you have to be able to justify any additional costs as being relevant and still being able to show that the best interest of the client was served.
During the panel, several people mentioned the issue of trust. And
Right.
trust, not only being able to trust your advisor, which most people blanketly do,
Right.
but also the issue of distrust of the financial services industry itself.
We, as an industry, I think, constantly underestimate the importance of the vast amounts of distrust for Wall Street. I use as one example, there's a quarterly financial investors audit to measure how well investors do trust Wall Street. And between December 2008 and December 2010, the trust level of Wall Street increased from 11 percentage points to 16%.
Not very much.
Well, to put this into context, when Richard Nixon resigned office in disgrace, 24% of the American people still supported him. So Richard Nixon had more trust, in a sense, when he left office than Wall Street does today.
It's a pretty extraordinary number.
It is an extraordinary number, and I think it's so extraordinary that it's hard to understand what that means. But I think that we are feeling it in the sense of the amount of money that is on the sidelines and hasn't gone back into the market. I think we begin to see some of it there, but longer term, I think the implications of the individual investor staying outside the market are huge, and they're negative. They get to the basic need for capital formation and for the economy to grow, and that is huge.
A point made by Aguilar as well the
That's
other
right.
day in his
Exactly.
speech.
Exactly.
Yeah.
Exactly.
So just getting back to the very fundamentals of the fiduciary duty, how does the SEC's fiduciary study change the course of extending the standard to all who give advice?
Well, the SEC study is an excellent piece of work by the SEC staff in terms of laying out some of the key differences between the two standards, and the stress, for example, on the duty of care and the duty of loyalty. That is important. But the SEC study needs to be viewed in the context of a very simple fact of life, and that is that it is a staff report that has not been endorsed by the commissioners themselves. In fact, two commissioners went out of their way to submit a dissenting view of the report, and so you can see that it is controversial within the SEC. So the impact of the study going forward in rulemaking, presuming there is rulemaking, is uncertain at best as of right now. But I think going forward, and maybe this is jumping the gun a little bit, there are several key areas where it's very uncertain, based on the study, and to the extent the study influences the rulemaking, it's very uncertain whether the investor's best interest is going to be served, frankly, or not.
Are there areas of concern that you have?
Well, I think the key area of two or three jump out. One is the industry, as well as some of the commissioners, have constantly spoken about the need to be business model neutral, which means that any rulemaking does not put a particular burden on one business model versus the other. And however that is interpreted in rulemaking could mean that either that the investors' interests are being put in not just in second place, but literally in the back of the bus, as opposed to the interests of the industry, or it could be done much more neutrally. But I take my hat off to Chairman Shapiro in terms of recognizing and saying this outright, that it is her words. In terms of reconciling being even to all business models and coming up with a quote-unquote meaningful fiduciary standard is going to be difficult, and she's acknowledged that. So That is one thing. I think another issue, frankly, gets to the heart of the duty of loyalty, and that is what happens with conflicts of interest. How do they have to be dealt with? And even though the staff study in some respects, as we would not be surprised, is a little bit ambiguous on some points, it's very clear, and several times over talks about the duty to deal with a conflict of interest being that either you have to eliminate it or disclose it. Now, eliminate or disclose, those three words are pretty straightforward and pretty clear, and on the face of it, there can be no ambiguity that suggests that disclosures have to be anything except disclosed. And by doing that I think creates a huge question about whether the fiduciary standard survives at all. And by this I mean that to simply disclose a conflict on its own and getting some form of assent is, in a sense, takes the duty and it transfers the duty to the client and takes the duty away from the advisor, because now we're putting the responsibility on the client about whether we're going to assent to this conflict. And when you do that, I think essentially you eliminate the fiduciary standard in that facts and circumstance, and that's huge.
That is huge. And we've also heard that disclosures don't always work in the way that you think that they do, that there's research that shows that they can be not just not effective, but actually detrimental in some circumstances.
Yes, there is research that shows precisely your point. It's not just a matter of that they don't work as well as we would like. It's not just a matter, and there's too much attention on trying to pair the right words to get the message across and come up with a certain pica size or point size in it, but and not enough attention to the point that is raised by this research in terms of, does it work at all, or and or does it cause some harm? Research, particularly from Professor Daly and Kane from Yale, some of the research suggests that it in fact has the opposite effect. It has the opposite effect in giving the advisor or broker the thought that he or she can go ahead and proceed in a conflicted way because he has disclosed. And so it's, in a sense, a license that he or she otherwise would not have.
And that's a very perverse effect.
That is a totally perverse effect. So instead of being helpful to the investor and providing some level of investor protection, it does the exact opposite and makes it worse. So one of the greatest concerns, sort of standing back and looking at the study and looking at rulemaking going forward, is the concern that all we're going to get out of it in terms of investor protection is more disclosures. And to go in that direction when we know that a lot of research suggests they don't work is hard to understand, particularly since I've yet to see anybody stand up in as an independent researcher and say, no. This new research that says disclosures don't work is actually wrong, and this is why it's wrong. So I think the point is that there has not been a general refutation of this research. It hasn't been out there. So that's a major concern. So
instead of disclosing, then, this comes to the 5 core principles of the Fiduciary Standard, which the committee has put forth.
Right.
Do you want to talk about that for a moment in closing?
Well, I think instead of disclosing, I think the key point is that the 5th principle, which requires that the conflict has to be managed or mitigated such that the best interest of the client is served. That's the core principle, that's the 5th principle, and that's what comes into play in terms of disclosure. And that's what matters in terms of making the fiduciary standard meaningful and actually serve as a protection for investors versus making it either so weak as to be irrelevant or basically removing it by just saying that I'm going to disclose and I'm going to put the responsibility back on the client, and that's how I'm going to deal with it. And that would be absolutely horrible.
Because it's not a fiduciary duty there.
To take the fiduciary duty off the shoulders of the advisor or broker and put it on the shoulders of the client, that in itself is perverse. It totally negates why we have a fiduciary duty in the first place. And we have it in the first place, not just through the Advisors Act, but through history, because of the unequal footing between the expert on one side and the layman on the other side. And because of that unequal footing, going back centuries, we have this special responsibility by the expert to put the client's interests first and not expect the client to second guess and to challenge the expert. And that's part of history, and that is what would be undermined by having a regime that is maybe called fiduciary, but it essentially is just increased disclosures.
And that is a good note to close on.
Thank you.
Thank you, Knut.
It's a pleasure.